Say what we're seeing right now in our current environment. The departing chairman of the SEC described it as a game of regulatory Jenga. You've got those blocks piled up on one another, and then you keep pulling things out, and nothing may fall down. But at some point, you pull the wrong block, and the whole thing comes tumbling down. So the two transactions that really are near and dear to this group's heart both involve Verizon, and I know quite a bit about the Verizon pension plan because I've been looking at the plan and every amendment and every investment report that's been filed since 2012 when they did the first group. In 2012, Verizon transferred $7.5 billion in liabilities, but they paid $8.5 to the Prudential Insurance Company of America, which was almost $1 billion premium. And there was all sorts of litigation against that was filed by the late great Curtis Kennedy that went all the way to the United States Supreme Court, specifically about analyzing the insurance company financials and showing where they were taking outside risk and where they were hiding liabilities in either offshore or onshore affiliated reinsurance companies that didn't report using statutory financial principles. And why is that important? Well, why do you think they transfer liabilities to an affiliate in a jurisdiction where they're not regulated? So they don't have to hold as much capital in reserve. Contrast that to 2024. 2024, Verizon offloaded $5.9 billion in pension liabilities to the same company, PICA. The $5.9 billion cost Verizon $5.7 billion. So now you say, okay, why in the first case did they transfer 7.5 for 8.5 billion? And there's $1 billion premium, and then fast forward 12 years, and they get off risk for 5.9 billion, but they only paid 5.7. Why is that? Because they take so much credit for reinsurance with affiliates, they're able to bid more aggressively for these big jumbo group annuity contracts. They want what they call sticky capital. That means a big upfront premium that, in the form of a group premium, that they can invest over a long term. And if they make great money on their investments, you may not notice anything. But if they don't, you have no visibility into what's happening with all the stuff they've transferred to their affiliates. And they transfer it to affiliates in Arizona, where there's no reporting. Financial statements are secret by law. There was just a captive insurance law passed in Iowa, where it made it a crime for the captive insurance company to disclose its financial statements to the public. Because insurance commissions are not looking at the risks that are right in front of their eyes. So anyhow, the case that we talked about in the second one that we brought right now was Dempsey versus Verizon Communications. That involved 56,000 retirees. It was premised on breach of fiduciary duty. Unfortunately, an older judge, the same one who had the Maduro case, kicked the case out on standing grounds and said, Verizon didn't really take $200 million that was supposed to be for the retirees. That's just an accounting entry. It's not real money. Well, it's real money. It's real money because under ERISA, the assets in the pension plan are solely for the benefit of the plan participants. They're not for the benefit of the plan fiduciary. So we brought cases against Bristol Myers Squibb, Alcoa, Lockheed Martin, AT&T, General Electric, Lumen Technologies, and ATI. Of those cases, the case that's closest to getting up to a federal circuit court is the Lockheed Martin case, and that's in the Fourth Circuit that came out of Delaware. The next closest is the Bristol Myers Squibb case, which is in the Second Circuit, the same circuit as the Verizon case with Dempsey versus Verizon, but in the Bristol Myers case, we got a very good opinion from a judge, a young judge, Garnett, and so that has been certified for an appeal to the Second Circuit. So we're watching all of this and keeping very close tabs on what happens. So there's really two key issues in all of these cases. One is, can you establish what's called Article 3 standing? In order to establish Article 3 standing, you have to show that the pensioners have suffered current economic harm. This has been a huge hurdle. It was a huge hurdle in the first case that went all the way to the Supreme Court. Ultimately, it was decided consistent with a case called Spokio, which basically said if you can't show current economic harm, you don't have standing to sue. Now, we've brought these cases alleging not just that there's Article 3 standing because the benefits are worth less the day after the transaction than they were the day before, which means there's harm, and there's a diminution in value. But in order to show that, we have to show that it's substantially likely that the insurance company is going to fail, and that that failure is imminent. And what the courts haven't been able to figure out is, what does imminent mean? We right now do not have an answer to that very important question. And that goes to Article 3 standing. And the next part of the cases, which goes straight to breach of fiduciary duty, is after the executive life debacle, Congress amended ERISA to give people the right to sue over the choice of the annuity provider. And some judges have just said, that doesn't count. And obviously we're going to fight that all the way to the Supreme Court if we have to. But those are the two key issues. So, why is it important? Well, it's important because the insurance industry likes to say there's never any insurance company insolvencies. And they're so rare that Stone is just making all this stuff up. Not true. We talked about some of the lawsuits, and we talked about some of the issues. But what do lawsuits do? Lawsuits can be useful. They can be useful tools, but it's not enough. We really need to change the law in this country, and we can do it at the state level, and we can do it at the federal level if we keep our eye on the ball and we don't give up. We've already done it. We passed groundbreaking legislation in the state of Connecticut, groundbreaking legislation in the state of Virginia, all sponsored through this association. And we have many other initiatives that are underway right now. And as these things happen, I hate to say it, but it'll probably take a big-time insurance company failure to get this more traction. So we've got a lot of regulatory efforts underway, legislative efforts at the state and the federal level. On the state level, it's just passing new laws saying, hey, if retirees in this state are impacted by these transactions, here's what they should have. Let's restore those creditor protections. Let's get them some disclosures. Let's make the other people hold reinsurance for their benefit or post a bond. And let's make sure that they provide some information about how they're doing so you don't find out when it's too late to do anything. So that's what we do at the state level. And at the federal level, we have to amend ERISA again. Its teeth have been eroded over time. It's time to put them back. So right now we're targeting certain states for certain specific reasons. One of them is Massachusetts, where there's a bill pending right now. One of them is New Jersey, because we have Frank Buzak. One of them is New York, where we meet pretty consistent resistance, but the PHL variable saga, I think, gives us a leg up that we're going to take advantage of. And the last one is Connecticut, where people are really starting to get up in arms.